Hi, welcome to the fourth installment of Money Mondays, part of Money Smart Month. I'm Peter Hoffman, Managing Attorney for Legal Services of Eastern Missouri. Thank you for joining us. For those who might be joining us for the first time, this is a regular Monday series, previous video sessions and slide decks covering topics like stimulus checks, circuit breaker tax credits, housing, and COVID resources for small businesses and nonprofits are all archived on Legal Services of Eastern Missouri's website at www.lsem.org. We usually kick these off with an update from last week. Here we have some news, some good news. The SBA resumed accepting Paycheck Protection Program applications from participating lenders today at 10:30 a.m. Eastern Time. There is additional information available on the SBA website. SBA also has links to all of the current COVID-19 funding options for small businesses through the CARES Act. So last week we talked about a lot of those benefits available to nonprofits and small businesses. Please visit those links to get an update. And we recognize that things are changing all around us all the time. So we'll do the best we can to update our presentations with additional information and keep you informed of any new developments as our series continues. A bit of housekeeping. Your questions today are encouraged. Please use the chat box feature on Facebook Live to post your questions there. We have staff standing by, might be able to help answer some of those. And then we're also going to reserve some time at the end of our session today to talk, to try to answer as many of those questions as we can. But just so you know, we cannot see the questions live in real time. So please do enter those and we'll try to reserve some time at the end to get to all of those. Today's presentation on estate planning is brought to you by our partners, which include the St. Louis Regional Financial Empowerment Coalition and the Carmody MacDonald Law Firm. I'd like to thank my co-presenter, who will be joining me shortly, Brad Zimmerman, an attorney from that firm, for taking the time to join us today to talk about this really important issue. A little bit about us, Legal Services of Eastern Missouri. We're a nonprofit legal aid organization. We're dedicated to serving the civil legal needs of people who can't afford assistance. We partner with the community to improve lives, promote fairness, and create opportunities for those in need. Without further ado, we're just gonna jump into a topic that I think should probably be on everybody's mind, but is probably a little bit more on people's mind given the COVID pandemic. We're talking about estate planning. And this is a topic that the attorneys spend dozens of hours a year in training on all the different tools and techniques to help their clients protect their wealth and make sure that they've planned for that day that's coming for us all when we're no longer able to handle our affairs or we pass away. And so we're just gonna really touch on some of the basics. Hopefully we'll be able to answer some more specific questions through the question box. But just generally, we're gonna just talk about kind of some basic terms and some basic techniques that clients can use, that individuals can use to help make sure their affairs are in order. And that's basically what we're talking about today. How do you get your affairs in order? How do you protect family wealth? One of the real benefits of estate planning is making sure that you choose what happens to you and to your property when you pass away. The state has certain default rules, which are called intestate laws, where the legislature has kind of guessed and said, okay, well, we think this is what this person would want to have happen to their home or to their car or to their personal property. Sometimes what the state has guessed that we want is not what we really actually would have wanted. So the only way to really make sure that all of your affairs are in order and all of your assets are protected and you're able to keep those things in the family and pass them on to the next generation is through some form of estate planning. It's an enormous benefit to your families as well. Without an estate plan, it can become really cumbersome and expensive for your family to claim some of those assets. It can take them longer. They may end up getting less. They may end up getting nothing at all. They may squabble with other family members, and nobody wants to see that happen. Sometimes, these types of things cause families to fall apart. The financial and emotional strain of resolving these matters right after the death of a loved one can be very difficult to deal with. So an unclear plan contributes to that family squabbling, and some of the techniques we're going to talk about today can help you prevent that from happening. One of the most important things estate planning can do is help you protect your children. So what happens if you don't come home from work one day? Who's going to pick your children up from school? Where are they going to sleep? Who becomes their guardian? Those types of things there's nothing more important in the world. So making sure that you've thought about that through an estate plan and take affirmative action to make those types of arrangements is really important. For your property, for most people, their home is the most valuable thing that they own. You've worked your whole life to be able to own a home and raise a family in that home. It's really important that you're able to pass that property on to future generations. Estate planning can help make sure that your family has money to pay the bills, has money for the funeral expenses. I mentioned real estate, transfer real estate quickly so that it doesn't deteriorate. And when we say the probate we want to transfer things outside of the probate process, that means outside of a lengthy and time-consuming court process, which we'll get into more in a bit. There's some financial benefits to different types of estate planning. Sometimes there's tax benefits. Sometimes there's benefits with respect to your creditors. And there's also benefits while you're alive. So estate planning is not just about death. People can become incapacitated suddenly. What happens to you? Who's going to make financial and healthcare decisions for you? We're going to talk about some of those. Brad is going to talk about some of those towards the back end of our presentation. Peace of mind. With your affairs in order, you can have the peace of mind and knowing that your beloved home, or maybe you got a mint car in the garage, that can go to somebody who's going to enjoy it and going to care for it. You can make contributions to organizations that you love and have supported your whole life to ensure that your legacy reaches the next generation. So it's a topic that's really important. I'm glad you're with us here today to learn about these different techniques, and I hope it's something you'll consider doing or thinking about if you haven't already. So we're going to talk really generally, as I mentioned before, about estate planning, but there's some specific terminology that's important to define up front. And so what we've tried to do here is just outline kind of a glossary of terms. We already talked about an estate, everything that you own. We've talked about probate, the court system responsible for probating wills and administering estate when there are assets that aren't otherwise accounted for. We are going to talk about just a handful of common tools, but do know, as I said before, there are a variety of estate planning tools and methods. They can be combined. They're not mutually exclusive. You can use different tools for different types of property. Unfortunately, time isn't going to allow us to get into all of those, but we hope we leave you with kind of a general understanding of some of these options. And at the end of the presentation, we're going to provide you some resources and information for people who may want to seek assistance from an attorney. Okay, so where to begin? There are a lot of things that people can do without seeking an attorney. I think the good, when we have people contact our office for assistance, with estate planning, one of the first things we have them do is work to kind of pull together important financial documents, maybe kind of take an inventory of important paperwork, of assets, of debts, of things that you own, gather your information, have it in a safe place where you know where it is at all times. So when you make the decision to come talk with an attorney about some sort of estate plan, you have that available. There's lots of things you can do on your own too. We traditionally think of wills as the way to transfer wealth at the time of death, but there are lots of other types of estate planning, and a lot of estate planning doesn't require, as I mentioned before, an attorney at all. So you can pre-arrange burial and funeral arrangements. A lot of property that you own or accounts you might have will have a payable on death designation. So think about bank accounts, insurance policies, retirement plans. Almost all of those types of assets, or all of that type of wealth, has some sort of beneficiary designation where you can indicate on that bank account or on that policy who's the beneficiary. In many cases, you may have already done this. When you're with your employer and you're receiving those benefits, most of the time you'll be filling that out. For cars, which is a big asset for a lot of people, you can go to the Department of Motor Vehicles. You might even be able to do this online, but you can create a transfer on death designation for your automobile too. So when you pass away, that your car, your van, or your automobile can be transferred to a person of your choosing. So there's lots of things you can do short of visiting an attorney to try to get some of this property to transfer instantaneously upon your death to somebody of your choosing. We talked before about the importance of real estate, and for most of us, it's the most valuable thing we own. In Missouri, like several other states, there is a non-probate transfer for real estate as well. It's called a beneficiary deed. It's kind of like, as I described before, the transfer on death for your automobile. Think of it as kind of a transfer on death for your house. So a deed is an instrument, a written document that conveys title to real estate. So when you bought your house, maybe you got a warranty deed. People always think of monopoly, you get the deed to a property. A beneficiary deed is similar, except when it conveys property, when it transfers title, it isn't triggered until you die. So that property actually remains in the name of the property owner up until the point of their death. We have lots of people who come into our office who say, I'd like to add my daughter or my son to the title of this property. Joint ownership is what that's called. And it is one way to make sure that that asset has somebody else's name on it, somebody else that can care for it. But what can happen with joint ownership of property that we've seen happen before is maybe you add your son to title, and then your son maybe goes out and gets a loan against the property, or maybe your son or daughter has a judgment against them, and then that judgment attaches to the property. One of the benefits of a beneficiary deed over that type of joint ownership arrangement is that property never leaves your name. It's in your name the entire time that you own it. And then through this written document, again, it's a piece of paper, it's signed by you, the property owner, it's notarized, and it's recorded with the county or city, in the city of St. Louis, recorder of deeds. So wherever that property is located, that's where that beneficiary deed is recorded. And again, it doesn't transfer title up until the time of your death. So it remains in your name, but at the time of your passing, title's transferred instantly to your beneficiary. Your beneficiary may need to take a few extra steps to get that transaction complete, to get that property in their name. So typically they'll have to go downtown or go to the recorder's office and file an affidavit of death. That affidavit will say, I'm the beneficiary on this property. My mother owned it and she passed away on this date. And that will kind of update or refresh the property records to reflect the change in ownership. As easy and as kind of straightforward as a beneficiary deed is, I would still recommend that people seek the advice of an attorney in drafting one of these. One of the things that is really important when drawing a deed is to make sure that the legal description is accurate. If a full legal description isn't used on a piece of real estate in a deed, it can create what are called clouds on title or title problems that can really impact your family a little later down the road. Another reason to seek advice from an attorney when drawing a beneficiary deed is sometimes when you're thinking about leaving that property to multiple people, sometimes it can get a little bit complicated. How do you want those two people to own it? What do you want to happen if one of them should predecease you or die before you do? So there's a few different wrinkles to doing a beneficiary deed that it's important to consult with a professional about, to make sure that some of that magic language or enabling language is included in the beneficiary deed so that truly your wishes are met at the time of your passing, and that title is transferred smoothly over to your beneficiary. Legal Services of Eastern Missouri through the Neighborhood Vacancy Initiative does provide free beneficiary deeds to city residents who can't afford an attorney. So income and residency restrictions apply, but we do encourage people to contact our office at 314-256-8778, 314-256-8778 for city residents to apply for a beneficiary deed. I'm going to hand it over to Brad Zimmerman from Carmody MacDonald. But before I do that, Brad's going to talk a little bit more about, he's going to wrap up some of the non-probate methods of estate planning and then get into some probate methods as well. Before I turn it over to him, I just want to remind everybody who's joining us, thank you for joining, for hopping on and participating in Money Mondays. Please submit your questions through the chat box in Facebook Live. We can't see those questions live, but we're getting set those questions as they come in. There's also Legal Services staff trying to respond to some general questions if they can. Please be mindful to not provide or share any personal information when you're sending us questions. And at the end of the session, we'll take about 10 minutes to try to get to as many of those questions as we can. So thank you again for joining us. And I'm going to transfer it. Sorry, I'm going to toss it over to Brad Zimmerman from Carmody MacDonald to take it from here. Brad?
Thanks, Peter. Hi, everyone. This is Brad Zimmerman. I am an attorney at Carmody MacDonald, like Peter said, which is a St. Louis law firm. And I have been practicing in the estate planning area for several years. And I'm happy to be here talking to everybody tonight. So one of the first things I want to talk about is kind of our last topic regarding non-probate transfers, and that is the use of trusts as a non-probate transfer. So you may have heard of a trust before, and a trust is a written legal agreement between the individual creating the trust and a trustee. And the trustee is the person that they are naming to manage those trust assets. So whatever they decide to put into that trust. Kind of the most common type of trust that we see is a what's called a revocable trust, which just means that the trust is, you know what it says, it's revocable. So during your lifetime, you would be able to amend that trust document at any time. And so for a revocable trust, what most people would do is name themselves as the trustee. So the person creating that trust is the trustee, and they have the right to amend it kind of at any time. This is a pretty common estate planning tool because what you can do is kind of customize the language related to what happens to your property after you pass away. So Peter mentioned, the intestate succession laws, which is what Missouri has said should happen to your property if it's a probate asset. And one of the things, one of the most common things that people do with a trust is customize the language to say when their children might receive assets from the trust. So in Missouri, somebody who's 18 is considered an adult. I know when I was 18, I'm not sure if that was true or not, but a lot of people think, that's kind of a young age for somebody to be receiving their inheritance. So again, one of the common things we see in a trust is people specifying what age their children might be able to receive their assets outright. Whether that's it's on the slide, 25, 35, could be older. The nice thing about a trust is it's kind of up to you as the person establishing that trust. So there's all kinds of different types of trusts that we can use. Really, we were talking about revocable trusts here. There's irrevocable trusts, charitable trusts, special needs trusts, which can all get kind of complicated and is just a little bit outside of the scope of, what we're going to talk about here tonight. So, just again, one thing to keep in mind is the use of a trust, again, to have a little bit more control over what happens to your assets when you pass away. Kind of next topic, and maybe a document that people have a little more familiarity with, is someone's last will and testament. So this document is a legal paper that states who received your assets when you die. So really what this document does is it governs the probate process. And so again, it's only effective when you pass away. And in order to kind of discuss what the probate process involves, it's important to understand exactly what is and what is not a probate asset. So Peter spent some time talking about, different ways to have non-probate transfers while you're still alive. And so that's filling out those beneficiary designation forms on any life insurance policies you have, retirement accounts, bank accounts, go to the DMV and take care of that car. And like he said, most importantly, get a beneficiary deed in place for your house. And so what is a probate asset and what is not a probate asset? So let's take your bank account, for example. Let's say you own your bank account in your individual name. If you do take care of having that payable on death designation, let's say you name your spouse, or maybe you have 2 kids, and so you name your 2 kids 50-50. You pass away, that payable on death designation will automatically transfer that bank account to your kids. So that will not be a probate asset. Now let's take that same bank account. Let's say you didn't get that payable on death designation in place. You pass away. Now the bank doesn't know what to do with that bank account until the court tells it what it needs to do. So that is a probate asset. And so what that means is you're going to have to probate the bank account, the ownership of the bank account. And like Peter said, if you don't have a will in place, Missouri's intestate succession laws are going to step in, and it's going to tell you or your children or whoever's around what has to happen with those assets now that you've passed away. For some people, those default rules are okay. If you're married everything's going to go to your spouse. If you what it really causes problems for is kind of second marriages. Maybe if you're divorced, it can just get really tricky. So this is where we like to tell people to have a will in place. You get to say exactly where you want your assets to go. The other thing a will can really help with is making the probate process much easier. Some things that we like to put in a will would be, you specifically name who you want to be your personal representative, which would be the person handling your estate with the court. You can say that they don't have to post a bond, so that saves them a little bit of money. They aren't subject to court supervision. That's going to make things a little easier and less costly from an attorney fee perspective. Most importantly in a will, outside of dealing with your assets, this is the document where we would name a guardian for your children. So if you have minor children, this is a really important document to lay out specifically who you would want to be responsible for them if something happens to you. Like a lot of the documents we're going to talk about, wills have some very specific requirements that must be followed when you sign them, when you make them, in order for them to be legally enforceable documents. So in order to make a will, it must be 18, it must be in writing and signed. You must be of sound mind, or we say have legal capacity to sign. And it must be witnessed by two people who do not receive property under the will, and they must sign their names in the presence of the maker. So, I can't write out my will, sign it tonight, and then take it to the neighbor in a week and say, hey, will you witness my will? All of that needs to happen kind of all at once. Another word of caution with that is every time you make an update to your will, those formalities must be followed. So, we run into situations where somebody makes a will for themselves, and then a few years later they decide, I named my brother as personal representative and he moved to California, so I'm just going to scratch his name out and I'll put my sister's name in there. If you do that, you need to have those witnesses. All of those formalities must be followed each time. Otherwise, those amendments won't be effective. So just a word of caution. We see that every once in a while. Next, we're going to talk about some of our other tools, which we're calling our emergency planning tools. So really what we're talking about now is a power of attorney. So when we discuss your last will and testament, that is a document, again, that only becomes effective when you pass away. And now your power of attorney, this is the document that sort of helps manage your affairs while you're still alive. So there's kind of two different powers of attorney that we usually deal with. So one would be for your financial decisions, and the other is for your healthcare decisions. We'll talk about healthcare kind of on the next slide. So right here, we're talking about a document where you appoint a person to act as your agent if something were to happen to you where you can't do so. So again, this is where you're incapacitated. Let's say you get in a car accident and you're in the hospital for a while. Somebody needs to pay the bills and pay the medical bills. And so this is the document where you would name somebody to have the authority to do things like go to the bank and withdraw some money from your account to pay the rent, pay your car bills, make your car payments, any of that kind of stuff. Again, this is only effective while you are alive. And, this document you're going to lay out a whole bunch of powers that you're naming somebody to do on your behalf. So it's an important decision when you're deciding who to make as your power of attorney, because you're giving them a whole bunch of authority to do things on your behalf. Similar to a will, this document has some specific formalities that must be observed when you're entering into this. So you must be 18, must be in writing and signed. Again, you must have legal capacity when you do this, and must be witnessed by 2 people who we always suggest are, again, people who don't receive property under your will, just to sort of make sure that these are disinterested witnesses who are there when you enter into this power of attorney. So the next document, or could be the same document, is like we mentioned, a power of attorney for your healthcare decisions. This is similar to your general or financial power of attorney, except now we are giving that agent power over your medical decisions. There's kind of a distinction here, as you'll see on that 3rd bullet point, about a healthcare directive and living will. So for your healthcare power of attorney, we're really talking about sort of smaller medical decisions, not necessarily life-prolonging decisions that we'll talk about shortly. So these are simpler things. You're having a minor procedure, and you want the doctor to keep you informed while that's going on, or you want the doctor to keep your loved ones informed while that's going on. So keep in mind, medical professionals are always going to prefer to communicate with you while you're having those procedures, or just discussing your healthcare in general. But this kind of gives somebody the ability to make decisions for you if you're unable. One thing we always recommend is, again, Missouri considers anybody who's 18 or older as an adult. So, while your kids are younger, as their parent, you may be able to get any sort of healthcare information from their doctors. Kids who are 19 or 20, we might still kind of think of them as our children. But if something were to happen to them and they were in the hospital, you might not be able to get information from a doctor without having a power of attorney for your kids. So anybody over the age of 18, we always recommend that they get this document in place. So, it's not just for kind of the older generation. This is really for everybody. So a healthcare directive or living will, again, this is really the major healthcare decisions, what we've referred to as life prolonging procedures. So, there's a lot of law that's occurred in this area, some of it pretty public, in the past. And this is the situation where we're talking about, somebody has had, a really serious accident and is in maybe a vegetative state. And now we are making a decision on whether or not to, sort of pull the plug and, remove sort of artificial feeding tubes or water or any of that kind of stuff. Missouri law says that if you don't have a document that specifically states, that you want those kind of life prolonging procedures to be removed, if you were in that kind of situation, then it's going to be really difficult for somebody to do that for you. So again, this is, those really, really serious decisions. Just having kind of that healthcare power of attorney form, if you don't have these specific directions included in that form, you need to get those in place. So again, similar to our other power of attorneys and wills, This has some formal requirements when you sign these documents. Must be in writing, must be signed and dated, and witnessed by 2 people. And again, you must be at least 18 years of age.
Thanks, Brad. We do have a few questions. I'm going to leave this resource screen up for everybody so they can jot down those numbers. I have a question here. Someone asked, I've done a transfer on death / beneficiary designation for a niece, but I have an estranged nephew. Do my actions prevent him from making a claim to my assets?
Yeah, so I would say that transfer on death designation for whatever asset that is for, that is going to be pretty rock solid, that your nephew is not going to be able to make any sort of claim against those assets. Now, if there's, let's say there's a car that slips through the cracks and goes, into your probate estate and needs to be probated, it's possible that he could make a claim for that. But the items that you have a TOD, transfer on death designation for, those are going to be pretty well locked up and outside of his reach.
Yeah, I think you can never put it past somebody. They can always try to make a claim, but I think using those, as you mentioned, using those beneficiary and transfer on death designations is going to put you in a good place. Mm-hmm. The next question is about online wills. Should I use online wills? Can I use online wills? What are the costs of online wills?
Sure. So, I think the word of caution with online wills is just, it's kind of similar to the deeds where Peter discussed that, there's some pretty specific requirements and specific language and things. And so you just have to be careful that what you're getting is, a Missouri specific will, and it's going to conform to all of those, specific requirements related to signing and witnesses and different things like that. So, I would tell you something is certainly better than nothing. And I definitely understand that, it can be hard to find, a good attorney to give you some good advice at a reasonable price. And so if an online will is kind of what you can do right now, I think that's a good idea. But you might even just try to find some attorney to just give it a look over for 15 or 20 minutes. And, maybe they can kind of point out a couple things and say, this looks pretty good, but, maybe think about these 2 things before you go ahead and sign that. And, Peter, I'm not sure if maybe there's some resources that you guys have that might be able to help out with that just a little bit.
Sure. Yeah. Our Legal Services of Eastern Missouri, again, the income and service area restrictions apply. We have a volunteer lawyers program. So for people who can't afford an attorney, please do apply for services. The numbers listed there, you can also apply on our website at lsem.org. For those of you who can afford an attorney, the Bar Association of Metropolitan St. Louis, I'm sorry, it's a typo there, bamsl.org, does have a private attorney referral service. And I would just echo what Brad said there. I mean, a lot of people use these online wills and LegalZoom sort of kind of websites. But there is really a huge value to having a local attorney who's familiar with the state laws, who can help you really issue spot. So you may think, oh, I just need a will. But after consulting with an attorney, it's like, well, maybe that's not really the best estate plan for you. Maybe we can utilize some of these non-probate transfer instruments. Maybe we can come up with a simple trust or something like that. So I really think there's just a huge value to actually sitting down with an attorney in the state where you live to try to iron out those details. But I understand there can be some limitations to cost for that.
Yeah, I would just chime in one more time and just say, sometimes doing things like that can end up creating more problems than they solve. We run into situations where, they're trying to do things on their own, and they might sort of unknowingly create issues that take more to solve than if they would have just consulted that attorney in the first place. So you just have to be careful.
Another question is, if I have a beneficiary deed for my house, do I need a will as well?
Yeah, so I would say yes. So the beneficiary deed is going to take care of, for most people, their biggest asset, their house, and make sure that that's a non-probate asset. But, we still would recommend having a will in place, especially if you have minor children, or just to kind of make sure that if any of these assets fall through the cracks, that you've kind of got that taken care of. I would also add one more thing for a beneficiary deed is, that's real estate specific. So if you move, you would need to get a new beneficiary deed in place for your new home. So just keep that in mind. Those are specific to each piece of real estate. So if you move, sell your house, you would want to get a new one in place.
That's a great point. Thanks, Brad. Another question, kind of similar. What are the benefits of a trust versus a will for my home?
Sure. So there's a few things. I mean, one is privacy. So let's say, and hopefully you've got a beneficiary deed in place if you don't have a trust. So your home would be a non-probate asset. But if you do have to probate assets, the probate process is a public process because it goes through our court system. So if you're doing, something that you don't want everyone to know about, maybe, you have an estranged child and they're not going to get any of your inheritance. Doing that through a trust is a more private process. The other benefit is speed. So like we talked about, the probate process can take, minimum 6 months, usually can be more than a year. So doing that through a trust, if you have a trust and your house is in there, as soon as you pass away, whoever you've named as trustee, they can now instantly take over the management of that property. So if they wanted to sell your house, they could put it on the market, a couple weeks later. I think, really for a house, having a beneficiary deed in place versus having a trust, a lot of the benefits are kind of the same there. It's really, if you don't have that beneficiary deed, having a trust in place or owning your house through your trust would become a much better idea.
It looks like we might have one more question here, and it's about the limitations of trying to find a notary. A lot of these documents, including beneficiary deeds and wills, need to be, a will doesn't need to be notarized, but a beneficiary deed does. And right now, it might be hard to find a notary who can make a face-to-face designation and watch you, witness you do these. Are there, what are some of the rules right now with respect to trying to get things notarized?
Yeah, so Governor Parsons has issued an executive order related to remote notaries. So there is a process in place where you can get something notarized if you, kind of have to know a notary, I guess, whether that's, through your bank or, somewhere else, where they are able to notarize documents sort of virtually through a Zoom meeting or something else. We're kind of cautioning people that, in an emergency situation, that's probably a good option. But otherwise, it's possible that down the road, somebody could challenge Governor Parsons' executive order. And so, if you had a will or power of attorney or beneficiary deed, something like that, notarized via this remote notary service, it's kind of up in the air right now whether that stays in place or stays is determined to be effective down the road. So in kind of a non-emergency situation, it might be worth it to wait a few weeks or kind of see what else you can get done. But that is an option that's out there. It takes a little bit of coordination, but it can be done.
A lot of questions, so I appreciate this. Keep them coming. Another question is, can I change my payable on death designation if I want to? Is that a hard process?
Yeah, you can change that at any time, and hopefully it's not a hard process. So, bank accounts, you should be able to go into your bank anytime and ask them to update that information. Life insurance policies, it's usually just kind of a one-page form from your life insurance company. Retirement accounts, same thing, should be just kind of a one-page form. A lot of that is available online now. And if some of those policies are through your employer, you should be able to talk to kind of your HR department, and they should be able to help you out with that. But yeah, other than probably the DMV is going to be the hardest one to get updated, but everything else should be pretty simple.
Great. Another question, if two people own property together, this already sounds like a law school hypothetical. If two people own property together, can one person complete a beneficiary deed without the other owner? What happens if they do it anyway?
So the answer is no. So any property that's owned jointly, or really in Missouri, if I owned property and I was married, if I wanted to transfer that property, I would need my wife to sign off on it, even though she's not technically an owner of the property. So if you own property jointly, and one of you tries to enter into a beneficiary deed to transfer it to somebody else, it's going to be ineffective. And so I can't tell you exactly what will happen, but if somebody went and tried to enforce that beneficiary deed, it just wouldn't work. So, jointly held property, it depends on how you own it jointly. But yeah, that wouldn't work. I guess the one, yeah, it just wouldn't work.
Yeah, I think that's one of those. There's several questions related to beneficiary deeds about, how do I find the legal description for the property? Can I use this website specifically to find a foreign beneficiary deed? This kind of goes back to some of the other question about using some of these online services. And really the benefit of using an attorney is to make sure that you don't have to make sure you're, finding that legal description and getting all of your, commas and periods in the right space. That becomes somebody else's obligation. I assume you could potentially purchase a title report from a title company to make sure you get that full and accurate legal description. But we do a lot of beneficiary deeds here at Legal Services. And one of the things we commonly see when people use those forms, they're not state specific. So as Brad mentioned, in Missouri, the law that relates to marital people owning property is different than, say, California or something like that. So one of the things to really be cautious about when using any of these online forms, is that form may not be specific to the laws of your state and can actually create more problems when they solve. So in the scenario that Brad just talked about, where you're leaving a beneficiary deed to a daughter, but you're still married, you're making, you aren't transferring that property to the beneficiary that you wanted to transfer it to, and you're giving her less than your wishes. So it's really important, I think, to when you can. I know nobody likes to go visit attorneys, but sit down with an attorney, take the time to make sure that you're really trying to do these things the right way, because a lot of these little mistakes can really, they hurt you, and they can cause problems for your family who you're trying to do a benefit for.
Yeah, one of my favorite beneficiary deed stories is we had someone who was kind of trying to do one on their own, and they were trying to do a beneficiary deed for their apartment in the city, and they got the legal description wrong, and they inadvertently tried to transfer the entire city block to their children instead of their specific apartment. So you just have to be careful with that stuff.
It looks like we have one last question here, and it's about the full process of filing a transfer on death or beneficiary deed. We did cover that a little bit earlier. The beneficiary deed needs to be signed by the grantor or the property owner. It needs to be notarized, and it needs to be recorded in the land records in the city recorder of deeds. And when that property owner passes, it's the obligation of the beneficiary, typically who does this, will go down to City Hall. Some counties require a death certificate, but you really shouldn't have to do that. Sometimes it's as easy as a piece of paper. But you may want to contact your local recorder of deeds to see what information they need to update the record for that beneficiary deed transfer. But I think people should know that the public record and the legal ownership of the property are two different things. And so that beneficiary deed, as soon as that person passes away, that title legally belongs to the beneficiary designated on that document. What may not be caught up is the city's public record. The city might not know that your mother passed away or your father passed away. So really, when you're going down to the recorder of deeds after your loved one has passed away and you want to get your name on title, you're really just updating the city as to what that beneficiary deed has already done. You're saying, Mom died on this date. I'm designated as the beneficiary. You may just need to show a death certificate, and the city can update its record that way. So just want to make sure people understand that, if you're going on to the city assessor's website to look up property ownership, that the city and the public record may be different than who actually owns title to that property and what happens legally upon somebody's death. So I think it's just an important distinction to make. I don't think we have any other questions. I don't know, Brad, if you have anything you want to add as we conclude here.
I think that's it. Thanks for having me.
All right. I want to thank everybody for joining us. Another Money Monday in the books. Join us on Facebook Live next Monday at 6:30. We're going to discuss the impact of COVID-19 on consumer rights, specifically talking about COVID-19 scams and fraud. Reminder that tonight's slides and other COVID-19 resources are available on the Legal Services of Eastern Missouri website, lsem.org/COVID-19 updates. You can follow our Facebook page for additional legal information and updates. Again, want to thank Brad Zimmerman, an attorney with Carmody MacDonald, for presenting with us today on estate planning. Thank you again for joining us.
Thank you.
Good night, everyone.